How's it going, everybody? In this video, we're going to be talking about the Young v. Hawaii oral arguments that we had held today, September 24th, 2020. So let's talk about this. But real quick, before we jump into this video, if you think the only permit you need to carry a firearm is the constitutional and the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main sponsors of the channel, and that is Franklin Armory. Franklin Armory has shown me and this channel a lot of support. They really help fund and promote what we are doing here on this channel, and they help us spread the word about the Second Amendment and what we have to deal with here in the state of California, as well as they provide amazing products to California gun owners like the 3 California compliant AR pistols. They also tried to put the Title I out on the market, but were blocked by the state of California. But they also do other things like put amazing products out on the market for people in free states. So Franklin Armory is just an amazing company, and I cannot thank them enough for supporting this channel. So Young v. Hawaii, this is a case that has made it all the way up to an en banc hearing in the Ninth Circuit. Now, I'm not going to talk comprehensively about what all the Young v. Hawaii issues are and the nitty-gritty details, because I have a very extensive video that covers Young v. Hawaii, as well as the 3-judge panel's decision in Young v. Hawaii, and you can find that right here if you click on that tab. But real quick, just to understand what exactly this case all entails, this has to do with an individual's fundamental right to self-defense, and that fundamental right to self-defense extending to an individual's ability to carry a firearm out in public openly. This case does not entail an individual's fundamental right to carry a firearm concealed, because here in the Ninth Circuit, we already had the Peruta decision that essentially said that an individual does not have a fundamental right to carry a firearm concealed for self-defense. So that issue had pretty much been closed already in the Ninth Circuit, but it did not address specifically an individual's right to open carry. So Young v. Hawaii is all about an individual's right to carry a firearm openly in public for self-defense. And specifically, this case entails a challenge to Hawaii's statutory language that generally prohibits an individual from being able to get an open carry permit or a concealed carry permit. And specifically also the County of Hawaii's regulations and policies prohibiting an individual from being able to get those permits. And essentially the state of Hawaii and that county had not issued a permit for almost 20 years. And there's a little bit of discrepancy and some back and forth arguments about whether the state of Hawaii and the County of Hawaii have actually issued permits. But it appears that if they have issued any type of permits, it's been very rare and far and in between pretty much. They very rarely issue permits, whether open or concealed. So I'm just going to talk about my general takeaways after watching the oral arguments before the en banc panel in the Ninth Circuit. And after watching this a couple times and listening to what happened, I would say that this probably isn't going to bode very well for us. It didn't appear that Hawaii's representative in his questioning got a whole lot of pushback from the judges on the en banc panel. Callahan and some other judges did have a little bit of pushback against this state of Hawaii representative, but I think he fielded the questions a lot better than our side and the attorney representing Mr. Young fielded. And when you actually listen and if you watch the oral arguments, you will see that a lot of the judges actually had a lot of more critical and a lot harder questions asked to our representative and the representative Mr. Young. First, what I would say is there was a lot of discussion on both sides about the historical basis for prohibiting an individual from carrying a firearm openly. And that's not a surprise, because when you read the 3-judge panel's decision in Young v. Hawaii, a lot of it was based very heavily on the historical context of an individual's right to self-defense out in public and an individual's right to carry a firearm for self-defense. The 3-judge panel's decision was deeply rooted in historical context, going all the way back to English law and all the way up now to the 20th century. But I would say that our side got a lot of very hard questions, and they talked about the equipoise, and a lot of you probably were hearing that word, the equipoise, and what it means is just like a balance between two things. They talked a lot about the equipoise of regulations by various states, and what they were hitting at here is essentially the state of Hawaii's representatives in their briefings are arguing that if you look at the historical context, there are various states that actually put various regulations on an individual's right to carry a firearm openly. And they actually go as far as to argue that there were more states early on that prohibited an individual's right from carrying a firearm openly than there were states that did not have regulations. And I think our side kind of fumbled a little bit answering this, whereas the state of Hawaii's representative was very resolute in saying that first he argued that there wasn't even a 50-50 split, that historically it was actually more greater for regulations. But in those situations, essentially they were hitting at that you should err on the side of public protection and public safety instead of granting an individual's right to carry a firearm openly. I would have liked our side to be a little bit more resolute in saying if you have a 50-50 split, you should err on the side of caution in protecting core fundamental and Second Amendment rights. Essentially what the representative of Hawaii started to argue to the en banc panel was that Hawaii's statutory structure in itself requires good cause for an individual to have a permit either concealed or open. They argue that that good cause requirement is historically protected and is essentially there's historical context for those types of regulations. So what the Hawaii state representative started to argue to the en banc panel is that Hawaii's statutory structure in itself requiring good cause is essentially protected by the Constitution, is not a violation of the Constitution, doesn't go so far as to burden the Constitution. And just because the county has further restrictions doesn't mean that the whole statutory structure should be completely obliterated and found unconstitutional. Simply, it was just the county that was going too far in violating Second Amendment rights. And they go as far as saying that the state of Hawaii AG has even said that the county has gone too far. But the interesting thing, and I thought was good that our side retorted back to that, is although the AG's office has said that the county has gone too far, that they are not complying with even Hawaii's own statutory structure, the AG's office has not forced them to remove that regulation, and the county of Hawaii has not even indicated that they're going to remove those further restrictions. So as you can see, the state of Hawaii and their representative is almost arguing this kind of like mootness. There's not really an effect of the statute, that it's just simply one county going too far, and essentially that the court should not have to look at the constitutional basis of either the statute or the county regulations. All they should have to look at, and this is exactly what the representative of the state of Hawaii argued, all they should be looking at is whether that county's regulation is compliant with the Hawaii statute, and if it is not, then find that county regulation invalid, but don't find the whole structure unconstitutional. It's kind of what they were arguing. Now, one interesting thing that I also wanted to note that I got out of the oral arguments had to do with the state of Hawaii's representative almost conceding, and actually did concede, that an individual's right to self-defense and almost an individual's right to carry a firearm out in public for self-defense was a core fundamental right and struck at the core of the Second Amendment. But to weasel their way out of this in essentially saying that although this is a core fundamental right, strikes at the core of the Second Amendment, the Hawaii state representative essentially argued that we don't even look at the levels of scrutiny. We don't look at strict scrutiny. We don't even look at intermediate scrutiny. Instead, we look at this kind of historical basis to define the scope of whether this right should fall into one of those categories. Now, they had probably the most pushback on this specific issue, and it was a little bit confusing to even me what exactly the Hawaii state representative was arguing. It almost appeared that he was arguing that something could be a core fundamental right, strike at the core of the Second Amendment, but when you look at historical bases, that would then essentially put it whether in strict scrutiny or intermediate scrutiny, that something could be a core fundamental right. There could be a statute that strikes at the core of the Second Amendment, but also fall and be required to be analyzed under intermediate scrutiny, which doesn't traditionally track with what you see with jurisprudence. Essentially, if something strikes at the core of the Second Amendment, it falls under strict scrutiny. That is the standard. And so I think the Hawaii state representative got a little bit of pushback on this because they have almost conceded through all their briefings and even below before the three-judge panel that this type of regulation would strike at the core of the Second Amendment, and that an individual has a fundamental right to self-defense, which has been established by Heller, as well as an individual has a fundamental right to self-defense, not just in their home, which was dealt with Heller, but also a fundamental right to self-defense beyond the home, out in public, and an individual's right to bear arms out in public for self-defense. So they're trying to find a way kind of around that and find a way around applying strict scrutiny, which the three-judge panel did. And so they're trying to use this historical basis to essentially get it to be put into intermediate scrutiny instead of strict scrutiny. In watching this, digesting it, and kind of listening to it a couple times now, I would say that this is not as clear-cut of a favorable decision like we saw when we listened to the oral arguments in Duncan v. Becerra before the three-judge panel, or even when you listen to the three-judge panel below in Young v. Hawaii hearing this case. Those judges were a lot more favorable to Second Amendment and gun issues, and you could really hear in the oral arguments that they're more favorable. But This panel of judges had a lot of pushback on our arguments, didn't have a whole lot of pushback on the state of Hawaii's arguments. And also a lot of judges didn't even ask the state of Hawaii's representative questions. A lot of them just declined to ask them questions. And so this signals to me pretty much they've made up their mind, or they were pleased enough with what the state of Hawaii's representative was arguing. So I'm definitely interested in seeing how this plays out. But if you were to ask me maybe a percentage of this working out in our favor, I would say maybe 20%. I'd say it's very much more likely that they are going to reverse what the 3-judge panel said down below, probably use intermediate scrutiny and find that the state of Hawaii's statutory structure and their good cause that they allege that they have attached to their statutory structure does not violate the Second Amendment and therefore is not unconstitutional. But that's just my general takeaways after watching this a couple times, and I'll probably watch it a few more times, and if I have any additional thoughts that come to mind or anything else that pops up to me, I will definitely let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is join the Patreon page, and I'll go ahead and put a link down below to the Patreon page. Also, just like, comment, subscribing, and make sure you hit that notification bell because it helps the channel analytics, helps spread the word about the Second Amendment, helps spread the word about what we have to deal with here in the state of California and the various infringements that the state has on our constitutional rights. So as always, thanks guys for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.